morning, good afternoon, and good evening, everyone. I would like to welcome you to the webinar, Digital Justice in the Pacific Region, Papua New Guinea Experience, where we will cover the topic of digitization of case management in the judiciaries and the impact it has. My name is Levon Kirakosyan, and I'm a senior project manager with Synergy International Systems, the developers of case management system for Papua New Guinea named PNG ICT. It is my pleasure to introduce to you our two panelists, Mr. Ian Augerea, who is the Registrar of National and Supreme Courts of Papua New Guinea, and Tony Lansdell, who is an ICT advisor consulting different organizations and non-profit organizations in their processes, focusing on judicial processes. I would like also to mention that all the participants will be muted during the webinar, and we encourage you to submit your questions using the questions chat feature of the Zoom and address them to David, who is my colleague from Synergy International Systems. Now, today we are going to discuss the digitization process in the courts and the impact it has on the overall case management. And I would like to start with you, Registrar, and welcome you to the webinar and thank you for your participation. And if you don't mind, I would like to ask you some questions. The first one being, what originally inspired you to implement case management system, and how long ago did you start thinking about it? Registrar, to you.
Good morning, Levon, and I think it's good afternoon, Tony, and thank you for having us on this webinar here. The digitalization of court case records. The thinking has gone for Papua New Guinea started a long time ago. I think during the time of our first National Chief Justice, where the thought was put into motion to look at moving from the traditional pen and paper recording of court data to electronic. So I think we're back in 1994, 1995, and Chief Justice Ahmed, we began our first steps into digital programs for the court. The first database we created was was created for us by an Australian consultant. It basically was a register of cases, not a case management system. That began also at the same time that we developed our court reporting system. They grew together. So from that time, around mid or early 90s, we now have the court reporting system, but we have changed the case recording system. Now, the one that was created was Excel, but when the new Chief Justice came on board in India, he decided to venture into more detail our search for electronic databases. Around 2008, we did the stock take of all the files, manual stock take, across all our registries around the country. The stock take took us back to 1948. Files that were registered back to 1948, and up until recently. So 2008, yeah, 2008 to 2012, we completed that exercise. And we also at the same time had a consultant from JICA who helped us set up what is called now our case document system. Now, the case document system is built around St. India's view of what was necessary. And that was ready around 2012-13, when we started to move all the data from our previous Excel-based database and plus our stock take, we put everything into the new CDS. Now, the CDS was from 2012-13 till we are still using it. It has been our main court register, but we realized when we were using it that it was not a case management system in a sense where ICMS was not a case management system. So once that was going on, we again with the consent of the Chief Judge and other people in Australia, we started searching for another system that would help us. So we tendered publicly twice, once in 2010, I think, and one later on in 2015. Yeah, 2015 for tender for case management, court case management specialist to, offer us the services. And around 2015, we got our tenders board, company's tenders board. They don't want to do the tender in and securing a contract for us. They nominated a group, a certain group, whereas ourselves in the courts, we went for synergy. So for a time, we were negotiating between them and us as to who would be the final person to be engaged. And around 2017, we both agreed to get synergy, and synergy came on board. 2018. After a few months of collaboration with synergy, we started off with the first what they call training site for us. I think in late 2019. Yeah, late 2019, we were on the training side. We were training our people, all of that. And early 2020 was training, continuing our training of lawyers, staff, and judges. We got hit by the COVID situation that hit the world. So around March, we decided, well, we are going to close down the court registries around the country, and we are going to switch on the ICMS, whatever states we were at. We switch it on and we start using it. So that's what happened in from March last year, March 2020. And now most of our civil cases are registered under the ICMS. The CES is still existing now, still being used now because there is close to 24,000 cases on the CDS, but 12,000 live ones. So we need to get rid of them naturally through CDS, and then we concentrate on ICMS. So that's the situation with our journey of moving from paper and pen to electronic data recording.
Registrar, as you said, you went through a public tender, and in 2018 we have been selected and started our work together since then. And during these years and during the implementation process, you have been a huge part of the PNG ICMS. I would like to know, what were you looking forward the most when we were transitioning together to the digital case management?
Okay, well, what was the problem that was plaguing us for a long time was the accuracy of the data. I can remember in those days when the Chief Judge wanted information, we would scramble in all over the place, trying to get the best data that we could get. And sometimes it will take us a few days or a couple of weeks to put a letter together. So we realized that what we wanted was something that would give us, accurate information on the date that is required, the time that is required. That's the number one thing, the accurate information, because then it will give us a clear picture of the kind of what environment we're working on. So when we went into ICMS, we were looking firstly for the accuracy of information, and two, the ability to properly allocate and equally allocate cases to the judges, and thirdly, to be able to know the status of each case at any time during the life of a case. So those three things we were looking at, and right now we are happy that the ICMS is providing us that information.
I'm very glad to hear that.
Unlike before, yeah.
Registrar.
Sorry, like I was saying, yeah, go ahead.
I'm sorry. And besides transparency and having a better track of all the cases, understanding that judicial processes themselves sometimes are complex, did you have to make any legal changes in judicial processes for you to be able to implement digital case management?
Yeah, when we were considering and when we were putting in place the ICMS here, we also had in mind that there would be legal requirements, especially on the rules on how the process was been carried out. So one of the first things we did was we tried to make sure that we kept within the current rules. Okay, we kept within the current rules. Where we found that we needed to go outside of that, the judges, especially the DCJ, guided that process there. But one thing we also found was that we were changing the practice for lawyers in terms of processing and lodging the documents. At first, there was some resistance from some lawyers, but later on, the lawyers began to see the benefit of electronic filing, for instance, as against over-the-counter filing, and the number of times the documents were misplaced or lost was just significantly cut off when we started going through electronic filing. So, the benefits were being witnessed from the very beginning. But we are also mindful that the rules will have to be changed to accommodate this. And that's going to be worked on by a rules committee and at a later stage. But for this, during this process that we are going through, we have decided to deal with different issues by way of practice directions. So there has been a draft practice direction that we have prepared, and it's for the discussions now, and whether the judges approve, we will release that shortly.
Continuing on the topic of improvement in the judicial processes when implementing case management systems, Registrar, what would you select as the top achievements of PNG ICMS overall within the judiciary?
Okay, well, our experience has been 1 year, but now, for instance, we can at any time go into any case and advise a judge of the status of the case. We can at any time go into the full list and advise the judge manager which judge has more case, which judge has less case, which judge is doing a lot of work. So I think the greatest achievement now is that we have data on our hands that can help us at any time to make decisions that support the courts in the line of cases. And if we have data that in the past were not readily available to us. And we also have data that are accurate. We have enough data to make these things as to how the court is to be administered. Plus, we have more data that we can generate and give to other people. Like, for instance, I am able to generate data for the Solicitor General and tell him, these are your number of cases that you have before me now, or before the court now. And this is the size of the monetary claim against you. So, such information, the Solicitor General, others do not have, we have them in the registry.
Yes, sure. Neatly kept data within the system is the key to the success and the possibility to provide later on reports, etc., and have transparent case management, correct? Registrar, and since we are already within a year are working and went live with PNG ICMS, I would like to know what, in your opinion, would be the next step for the judiciary in scope of the case management system enhancement?
Okay, well, the judiciary here, we've started this journey, as I earlier said, a long time ago. And I think this journey is going to continue for us. We want to give similar kind of data to other law and justice sector agencies to help them with their work, because we have seen now in a short space of time here that where you have all that necessary data that important for the work that you do, you will be better able to organize yourself, your resources, your manpower, whatever that needs to be properly managed. And having data such as the one that we are now generating through ICMS is really sort of indicated to us that in order for the court system here to move forward, we need to bring our partners as well, our law and justice sector partners. And so whilst it is our aim to continue to develop and improve on our electronic or technology case management systems, it is also our desire that we should bring our partners, law and justice sector partners, and even the law society into this the new scheme, new way of doing things that we are now undertaking.
Thank you, Registrar. And let's start with the answering questions that have been submitted using the chat feature of this Zoom. And I will encourage everyone to continue submitting their questions using the chat feature. And the first question, Registrar, that has been brought in is how judges welcome the PNG ICMS and the transition to the digital case management system.
Okay, now we have judges who are some of them well into the 60s, 70s, and there's some judges 50s and around this age group. The older judges are taking time adjusting. Younger judges, some of them with tech savvy, they are adjusting to that. So what I've observed is that as a group, because these changes have been championed by the chief judges and deputy chief justices, as a group, a collegial group of judges, they accept that this moving into technology will have to happen. Technology will be necessary for the future. It's just the level of slowly getting themselves into the use of technology. So we are aware of that, and so part of our plan is to get the associates involved in this exercise. And also the team is ready and able to visit judges on a single one-to-one basis, train them and help them through the process.
Yes, and the training and knowledge transfer is the key factor when implementing such projects and training the staff on how to transition from the paper-based to the digital case management, correct? And we have together conducted that first here in Armenia, and then it has been continued by you on the ground. The next question, Registrar, is what should we consider when choosing a technology vendor for court case management systems?
So I did not get that.
Yes, so the question is, what should we consider when choosing a technology vendor for case management system?
Okay. Well, for us, we had assistance or contribution from different people. Like, for instance, we had the Federal Court of Australia, who used the technical people to advise us on case management and case management technology. We also had Science of Sarawak. This is from Malaysia, who also came and showed us the technology. And none of us here in the group here, that when we started off, had any knowledge whatsoever about case management technologies. But we went through everything. Like, for instance, there was, when the Science of Sarawak were with us, people were advising us that these fellows were very high-tech group. What they were supplying to us was, there was somebody who said, look, you are trying to buy a Rolls Royce, but what you need is a Toyota Corolla. So that kind of things were taught, those kind of comments were given to us. But we've decided that what we needed was that get from whoever the vendor was a simple explanation of what they were going to do for us. Once we understood what they were going to do for us, then we can go in and look at the technology with them. So the key for us was, if what this guy is offering is easy for us to understand, well, let's go and talk with him and see what kind of technology is good for us.
Registrar, once again, thank you very much. It is our pleasure, and once again, I would like to mention the team and working with you. It's an honor to implement PNG ICMS in Papua New Guinea, and I hope we continue to work together for many years ahead. Thank you very much for all your answers and sharing your experience of implementing digital case management system. And now I would like to move on and welcome once again our second panelist. Meanwhile, I will encourage our participants to submit their questions via the chat. And Tony, I would like to welcome you once again. And it will be hard for me to introduce you in a concise manner, taking into the account your over 27 years of experience providing business and system consultancy services to a wide range of organizations with the focus of justice within the courts and agencies. You have implemented different projects and consulted in implementation of such projects in different countries such as Moldova, Lesotho, Tanzania, India, Ireland, and together now with you, we are implementing that case management system for Tonga named Tonga e-Case. And welcome. The first question that I would like to ask you would be, what steps do Pacific Island countries usually go through when they are in pursuit of having a case management system?
Thank you, Levon. But first, thank you for the opportunity, and to Synergy and yourselves, and also to Registrar. It's a privilege to follow and on from you. We've known each other for several years, and certainly watching your journey there in Papua New Guinea, as you've moved, as you said, from the old Excel up through CDS and now heading down the path of IECMS with Synergy. It's a credit to you and to everyone there, the patience and the perseverance and the journey, and we'll certainly reflect on the journey throughout, I guess, the rest of today's session. Just by way of background, I'm in the fortunate position of being able to reflect on, the 15 Pacific countries in my role with New Zealand MFAT and the Pacific Judicial Strengthening Initiative. So I have a pretty good handle on what's happening across the Pacific. And as we all know, the Pacific, the 15 countries are very different, not only in terms of their size, population, their funding arrangements, but also in their sort of technical and, infrastructure wise. It'd be fair to say about a third of the 15 are what I would say well on the path or there with what I call a case management system, a full functioning, robust system, document management, etc. They may be product, as PNG are heading down the path of with Synergy, or they may be bespoke or locally built, like the Solomon Islands and Palau. So you've got about 5, and those 5 have all gone through extensive lead-in activities through tendering and or raising the funds, etc. Recently, obviously, Tonga went through raising the funds, going out to tender, which can be a lengthy process. No matter what country, going out to tender is never a quick exercise. So you've got about a third that have made it to the sort of what I would call the big league. You've got another third that what I would say are on affectionately called a case tracking system. Less functionality, but also significantly less cost, less annual cost, and a lot better than Excel. So these countries are now operating judges, administration, operating off systems that can do quite a lot. But as I say, they're not necessarily at that sort of full end e-filing type facilities that you might get with a case management system. But they're well positioned, which is very good. And that's really happened in the last 2 or 3 years, that a lot of these countries have stepped up. The remaining third, still in that challenging period of either Excel, dare I say even sometimes still on the book, or some very rudimentary, almost like the old Microsoft Access databases. So they're really at a crossroad of having to do something. And their journey could be, if they wanted to move to CMS, finding the funds, going out to out to tender, entering into contract negotiation, or they may take an in-between step and look at something like a case tracking system. So you've got quite a range across the Pacific, and obviously sessions like today, people can sort of hear the experiences that the registrar is going through. One of the challenges that they all face is, if it's product, you've got a commitment to a vendor, obviously, such as Synergy. But then again, the flip side is if you go bespoke or locally developed, you're then very beholden to that particular individual or that group. So both product or bespoke development, both have got their challenges, and that's something that each country has to weigh up as to which direction they take. Really, whether it be a case tracking system or a case management system, they're all a lot better than Excel. They're all a lot better than the book. So, in effect, we've got 10 out of the 15 that I think are well positioned, for the next decade.
Tony, and speaking technologically, when we say we are moving forward with case management systems, what would be the top 3 specific trends that Pacific Islands are looking forward to?
I think if you asked me that question, Levon, in January 2020, I might have given you a different answer. As we all know, something happened in about February 2020 and the world has just gone upside down. And without a doubt, the number one technology that's being used, introduced, would have to be remote court proceedings. Audio visual in the old days, we'll just call it remote court proceedings. And the whole desire to continue to deliver justice, judges might be overseas, counsel might be overseas, can't travel. Courthouses might be sort of locked down. We need to conduct video conferencing sessions. so the embracing of this technology, it was always there. You know, video conferencing has been there for years. But dare I say, if there's an upside of COVID, it really has been the ramping up of remote court proceedings. Now, it has a real significant byproduct or by-benefit, and that is reducing cost. Because, you know, for a lot of parties, counsel are not, you know, flying in, even having judges on courts of appeal. There's, you know, reduction in cost. It may not necessarily be as good, but it's still a very serviceable vehicle by which. So that would be number one. And with it, you know, I think across the Pacific, there isn't a country that isn't embracing it at all. Number two sort of goes hand in hand with it. We sort of run our proceedings electronically, as in video, but we've also now got to be a bit smarter about how we move information, move the documents. So there's been a significant acceptance that we can move documents electronically. Quite a few of the countries are dabbling with e-filing, even if it's in the crudest form of an email, receiving the documents via an email and then being uploaded into the respective systems. But it's also distributing documents, and that could be to judges who are not able to travel. They're in a remote, you know, in another country. And for years, we used to have paranoia about that thing called the cloud. But now people are using Dropbox, people are using Google Drive, and other mechanisms by which to share the documents. So, you know, that has been a significant shift. But that then introduces a little challenge, because now we're potentially less reliant on the paper. We should be looking at these documents on the screen. And as the registrar mentioned, for the judges, for some, that's quite okay. I'm used to sort of looking at the screen. But for others, they may receive the document electronically, but then they'll print it. And that's sort of something I think courts generally right across the world, but certainly in the Pacific, we talk about e-filing, getting that document in electronically. That's step one. It's keeping it in electronic form that is as big a challenge. And we don't want to do like Singapore did in 2000, where they mandated e-filing, looked fantastic, and every single document was printed off so that the judge could still keep using the physical file. So we've got to do a lot of work, and I think the registrar touched on it earlier, in terms of supporting the judiciary, particularly, not just in terms of remote court proceedings, but in the use of documents in electronic form. So that would be the second. The third is actually just CMS. And I think, as the registrar was pointing out, greater access to information. Now, that could be at a statistical level, but it also could be at the judicial level for active case management. And I think case management systems typically were very data-centric. We registered the case, we registered the listing, we registered the parties. It was used by administrators. But now, really, for 2/3 of the countries, we've now got the documents as well as the information about the case. So now we're starting to see these systems being not only data-centric, but document-centric. And that then means that hopefully the judges will engage more with these systems than ever before. Not only less need for the physical file, but also for them to be able to manage their cases. And this brings me to sort of what I call active case management. And again, the registrar was sort of pointing that out. Often judges in the Pacific have got large cases in their docket, and the CMS can help them in understanding where their cases are at. Are they overdue? Do we need to make a future listing? Has it been sitting without attention for too long? So the CMSs, which for years and years and years were always just for the administrators, for the registry, now we're starting to see a much greater involvement with the judiciary. Still a long way to go, I might have to say, but it's all in the right direction. So I think they're the three big ones that I think we're seeing. Just on that last one with information, there is a sort of a growing need too to be able to present that information in a much more intuitive manner. You know, statistical reports that typically were pages and pages long gone. You know, the terminology now is a dashboard. You know, I drive my car, I've got a dashboard, I know exactly, I can easily see how far I've got to go, how fast I'm going, etc. And I think for 2/3 of the countries in the Pacific, this sort of dashboard type, not only for the administration, but also for the judiciary, getting them to be able to look at their totality of their work, use the dashboard. Again, it's all about helping them manage their cases, their caseload. So that's sort of goes with CMS, because if you don't have quality of data, you won't have trust in a dashboard. So, yeah, there's some 3 big ones, I think.
Yes, I completely agree with you. And indeed, case management and document generation within the case management go hand in hand, and there is no point of implementing such systems if the overall process is not included. And the overall process is always based on the documents. Tony, and the last question would be, what are the key factors for countries to take into account and preparing when they wish to undertake such complex technological and operational reforms?
Oof, you could throw this one back to the registrar. No, it was a good question. About 2 or 3 years ago, I was on a podium in Samoa, a judicial conference there, and pretty much the same question. And I followed the former CJ from PNG, Chief Justice Inja, and I had my 10 things of what I think are needed to make this work, you know, technology/case management systems. And lo and behold, the CJ Inja just sort of almost rattled them off as things that he was focusing on trying to make work in his move, obviously, that, as the registrar said, from CDS to IECMS. So we sort of dovetailed each other coming out. We didn't prepare, but we spoke about these 10 things. And certainly number 1 has to be leadership. And that really comes down to Chief Justice, Chief Judge, or delegate thereof. For without that, I think we'll always struggle in introducing new technologies. There's got to be a leader. And I can say, you know, hand on heart, with 25 years of implementing case management systems in various, you know, jurisdictions, countries, that's what I look for. Number 1, leadership. Number 2, I think there's got to be an acceptance by all that introducing the technologies, it's the start of a journey, not the end of a journey. There are certainly a view that once you've implemented, you know, we're all done and dusted. You know, we give ourselves a pat on the back and off we go. The reality is, it's only then that we really start to use the system, play with the system. We know what it can do. We know what we want it to do in the future. And there's a recognition, I think, that get the system in, and then you'll start to really understand it. So it's the start of a journey, not the end of a journey. Going with that, I think there's expectation management. And a lot of people, the funders, the governments, maybe even some of the judiciary, they sort of think that the introduction of a technology may suddenly make everything better. And it takes a long time to be bedded down into the operation, trust in the data that's there, the usage of the system. So managing the expectations, I think, is key, and that comes as part of the implementation. And that leads then on to engaging of the judiciary. And as the registrar said, although I was a bit taken back, registrar, you said people over 60. Well, I'm 63, but, you know, I think the engaging the judiciary, you got some judges who I work closely with who are well past 60, and you can't stop them on this technology. They just love it. But we know there are many who we just can't get them to turn on the computer. So this whole engagement and support to the judiciary is something I think we cannot underestimate. And again, that leads to the next one, and that's support. And obviously with the differing shapes and sizes, infrastructure of the countries in the Pacific, the level of technical support is one thing, but the level of user support is, if not more, critical. And what I call super users, those who can go to a judge, go to a registrar, help them out, give them the confidence in the use of the system, reassure them if they've got, a little glitch or whatever. And I think for some countries, quite well served by both technical and super user support. But there are certainly some countries where either one of those two is maybe not where it should be. And that really has potential for undermining all good work. So you've got expectation management, you've got engaging, and then you've got the support. Next one. Oof. And this I owe to Chief Justice Lunabek of Vanuatu. And he looked at me back in 2015 and he said, so the donor, at that time it was DFAT, they buy me the car, but who's going to pay for the petrol? I looked at him and I said, you are. And he said, well, I better start putting money away. And this whole ongoing commitment to maintenance, the ongoing petrol money, is a big impost. Donors love handing out the car, the shiny toy, putting up the money for the first up implementation. But whether it's a product or even if it's a bespoke system, that ongoing cost, and I have seen some shocking examples where just it was disproportionate to the value that the system was bringing to the organisation or to the country. So I think that's something that people have to have their eyes wide open. The registrar mentioned, and you asked the question about the legal procedures, rules, etc. I'm not maybe quite as polite, but I've often seen rules committees almost become roadblocks. And it goes back to the leadership from the CJ or whoever, that rules committees need to adapt quickly to the use of technology. It could be from e-filing. I've seen panic stations because we were going to change the file numbering regime. We've had panic stations because we were going to remove the book. The sun wasn't going to come up. We've got to have those roadblocks removed to give us the confidence to implement. Just a couple more. Favorite saying, don't let perfection become the enemy of implementation. And I think there's always the expectation that we want it perfect on day one. And if we're seeking that, we'll never get there. And again, another Vanuatu example, but the former Chief Registrar of Vanuatu once said to me after we went live back in 2015, now I know what I want. Because it's only when you see it, you know what you really want. Now, we didn't seek perfection. We just wanted to get the system in and start using it. And the requirements continued on, hence the start, not the end. So I think perfection, there's got to be a real pragmatism to that, and don't let it get in the way. Maybe last but not least is the adherence and focus on the data quality. For without it, no one's going to trust the system. The judges won't trust it. The bureaucrats won't trust the reports. If you start putting information up on the internet like many countries do, then that will only cause mayhem. So there's got to be this continual focus on the accuracy of the records. Date filed, date finalised, who it's with, what stage, what outcome, what order, those sorts of things. And that's not a Pacific issue. That's right throughout the world. That this constant attention to data quality can't be underestimated. So don't want to be they're all doable, they're all achievable, but I think eyes wide open. And as I said, Chief Justice Inja really spoke to those very well as I was then going to put them up. So they're just some of the things I think really, no matter what country, no matter what size, they're things to keep an eye out for.
Yeah, great points, Tony. And as you said, number one is always leadership, support, and I think that's the main success factor in the implementation of PNG ICMS. Now let's address some questions that have been submitted to us. And Tony, the first one would be, what is the effective way of implementing case management system in a small Pacific Island country? Does it make sense to do a small number of courts in the beginning and then scale up to the entire country, or entire country altogether?
Good question. Maybe I'll reserve judgment. I think it depends on the capability, but there could be many factors. The spread of the country, as we know in the Pacific, major islands within the sort of archipelago could be well serviced with technology, resources, etc. But then the further out you go, less access, less support. And that would make perfect sense to start central and then spread. But you have some countries where it's much more contained, confined, and you could do all case types. Similarly, you may start with one of the two jurisdictions, a higher court or a lower court. So I think you sort of want to do a bit of a stock take against those items that I mentioned before and just say, how ready are we to tackle? And even in my state of Victoria, we've tackled jurisdiction by jurisdiction, but you go across to another state in Australia and they do by case type. They do civil first and then they do criminal. So horses for courses, I think.
Thank you. And this next question is, when is the point when the judiciary should start thinking about adopting case management system after case tracking system? So the continuation, when should they start thinking about that?
I think that when you want to do more advanced features, like potentially putting information out on the internet, public search, or even search for party search, that has a level of security technology that would potentially be very hard for a basic case tracking system to be able to do themselves. Whereas for organizations such as yourselves, you've been doing it, and other vendors, you've been doing it for years. So that's an example where you're sort of looking at a piece of functionality that is going to stretch you in terms of potentially the security or the infrastructure. Another one might be when it comes to e-filing. Or it may come down to functionality like finances, reconciliations. So again, it would sort of be you could live on a case tracking system for a number of years. But if your appetite is there, you think you've got the capability and you want to explore external e-services, as I call them, then that might be the time. But again, you have to have the funds. You have to have the petrol money as well.
Thank you. And the last question, which is addressed to Registrar. With the embracement of the digital technology, how is the Supreme Court increasing its human resource to fully maximize the use of these technologies?
One of the immediate tasks that we are undertaking now is to restructure and realign the staff positions and staff roles to take on the requirements now of this ICMS. The Supreme Court, at this stage, the judges in the Supreme Court is sufficient. But with the introduction of ICMS, we are beginning to notice that there is a need for more accurate recording of data. So that means more staff trained in that area. So we are restructuring and realigning our people to take on this need for a new electronic case management systems.
Thank you, Registrar. And on that note, I would like to thank you and Tony for participating in our webinar and finding time. Here at Synergy, we are very honored that you have been part of implementation of two of new projects, PNG ICMS and Tonga e-case. And I would like to also thank all of our participants for finding time and attending this webinar, and also mention that the recording of this webinar will be available on our YouTube channel, which we share with you via email. Thank you all and have a nice day and evening.